However, you may remove your mask if you have the visitor sticker. You can take it off at the podium at your argument. When you go back to your seat, please put your mask back on. Thank you. Happy holidays, all. No, just do it outside before you come in. Please rise. Justice Appellate Division, Supreme Court, First Department. Hear, all persons having business with the Appellate Division. Go here, give your attention, and you shall be heard. Please be seated.
Good morning. Welcome to the Appellate Division First Department. We have over 7 hours of argument time requested today, so I ask that everybody only ask for the time that they need and not the time that they want. We have read all your briefs, we have read the record, and we are familiar with each of the cases. People versus Harnett, appellant. Okay, that is submitted. CJS Industries versus RS Custom Woodworking.
5 minutes.
5 and 5. Menace versus City of New York is withdrawn. Epic West 14th LLC versus Malter, appellant. 5 and 3. Respondent? 5, 1, and 5. People versus Moy. That is submitted. ABN AMRO versus Amera Capital, appellant.
The parties have agreed to submit and rest in our favor today.
Okay, so AMRO is submitted. People versus William Gay, and both of the appeals will be heard together.
Good morning. The appellant requests 8 and 2.
I'll make it 6, 1, and 6, and that's for both of the appeals. Woodson versus Convent, appellant.
Appellant 5 and 4, please, Your Honor.
I'll make it 5, 2, and 5. Are you requesting rebuttal time?
Yes, Your Honor. 2 minutes, please.
Okay, 5, 2, and 5, 2. Sinelli versus Greyhound Lines, appellant. Okay, that is submitted. U.S. Bank versus Nassau County, appellant. Appellant's not here. Do you want to submit it, or do you want time? Okay, why don't we submit it? U.S. Bank National Association versus Fox, appellant. Okay, that is submitted. Everybody wants to start Thanksgiving. GSCP versus ETC. Okay, I'm going to give 5, 1, and 5, and I am recused on that matter. D'Ambrosio versus Port Authority, appellant.
Appellant 8 and 5, Your Honor.
Respondent? 5, 1, and 5. Breslin versus Macy's, Inc., appellant. 5, 2, and 5. Breslin versus Macy's, Inc., appellant. Yeah. Oh, I'm sorry, I got a little confused there. So did I just give you 5, 2, and 5? Yes. Okay. SR and Infant versus BMW North America. And are you requesting time as the other appellant?
No, Judge, we're going to rely on BMW.
Okay, so I will make that 6, 1, and 6. Isufi versus Pro Metal Construction. I know there was some confusion, but I did give time to both sides. So appellant? Respondent? Okay, I'm going to give you 4, 1, 4, and 2. Okay, the first case is CGS Industries versus RS Custom Woodworking. Go ahead.
May it please the Court, Jeffrey Pope, Tremellian Wood, for the appellant. The proceeding below was to confirm an arbitration award, and as such, it was incumbent on the petitioner to submit with its petition, with its verified petition, sufficient evidence to dispel all issues of fact. This wasn't done. There was a petition, it wasn't verified, it wasn't made on personal knowledge. It was made by an attorney other than the attorney who had represented.
Counsel, I thought your main argument was that the wrong entity was sued. Isn't that your primary argument, that,
Well,
that the corporation who the judgment was obtained was not even in existence at the time that the agreement was entered into?
Well, it's both arguments. I don't know if one is more important than the other, because the first argument is jurisdictional. If there is no agreement, if there's no proof on the petition, then the court didn't even have jurisdiction to entertain it.
Can't we only
But yes.
decide whether there's an agreement to arbitrate if we know if it was the right corporation that's being sued?
I beg your pardon?
Can't we only know if there's an agreement to arbitrate if we know the right corporation was sued?
That's correct, yes.
Okay, well, let me ask you an argument about that, because it's a somewhat unusual record. Isn't it clear from the record that the sole reason RS Custom Woodworking was formed was to avoid paying the judgment on the petition based on the circumstances of this case? Because it was only formed immediately after the arbitration award was obtained. It was the same attorney who was at the arbitration who formed RS Woodworking. It seems very suspect in terms of the circumstances. Do you have any explanation for that?
I've never spoken with Mr. Dolce, so I don't really know what was in his mind when he formed the second corporation. And I had no involvement with that. But it actually, when they sued the wrong company.
Well, who did the work for Mr. Dolce in forming the second corporation?
Mr. Chimelli did, yes. But when they,
So isn't that very suspect, just based on the circumstances alone? Isn't this calling out for a piercing of the corporate veil or something of that nature?
Well, there
to
are-
remedy what perceives to be some questionable behavior on the part of Armed Custom Woodworking?
well, there are remedies if that is the belief. Okay, that what they should have done, we told them, we asserted the defense, we said you sued the wrong party. They said, no, we didn't sue the wrong party. Never mind that it didn't exist. They could have withdrawn, refiled. It doesn't change the fact that when you go to confirm an arbitration award, it has to be against the party who was involved in the arbitration. If the company didn't exist, what you would have to do is confirm your award.
Doesn't it seem unjust on some level, though, that obviously it's questionable the circumstances and that the court should allow that kind of behavior to be rewarded by not confirming the judgment?
I don't think anything changes. There is a remedy under the CPLR. You confirm the award against the correct party, and then you bring a proceeding under, what is it, 5225, and you claim alter ego, but there was no pleading, there was no proof.
What happened here is that the fact that originally you're doing business under RS Custom Woodworking, you were using that trade name, so then after they won the arbitration and they looked to confirm it, and how maybe this is calling for speculation, I recognize that, but how did they come up to make the Inc. the one that the judgment, that they sought judgment against? Where did that come from? Where do you think that came from?
Where did what come from, Your Honor?
That they sought to have the judgment entered against RS Custom Woodworking, Inc.
Well, I think it was in the papers. The counsel said that he'd gone online and that he had seen the Department of State record for the formation of the company. It didn't come, he
Well,
didn't,
what's the date in the Department of State records for the formation of the
October, following the
post the arbitration?
post-arbitration, and counsel didn't pick up the phone and call up Mr. Chimelli and say what goes. Had he done so, he would have been corrected at that juncture. He didn't. Instead, he just went ahead and filed without paying it and without surveying the record from the arbitration.
Thank you. Thank you very much.
Okay.
Good morning, Your Honors. Brian Brick for the respondent. I think that
As become apparent, this corporation was formed after the arbitration award, right?
it became apparent that that was the case.
So how is it that you sought to get a judgment against a corporation that's formed after the arbitration?
The Secretary of State records were formed. I think what was not noticed was the formation date. And the reason why is because there's one company here, and the court has picked up on that from the very beginning. The appellant was doing business with this trade name, RS Custom Woodworking, for 30 years. RS Custom Woodworking is the company that signed the master service agreement that had the arbitration clause. It is the company that was sued in the arbitration.
But actually, the business that was in existence that was doing business as RS Custom Woodworking was Dolce Custom Woodworking, Inc., incorporated in 1990.
A company which nobody knew about on CJS's side until they got to the arbitration, and then passively, there was an affidavit that Ron Dolce put in that identified himself as president of Dolce doing business as.
You mean that came out at the arbitration?
That's right. There was
So
no
you were
mention of
on notice
Dolce.
This issue.
Well, what is very clear is that the circumstances that we find ourselves in were entirely of the appellant's making, because they, and the court picked up on this, after losing the arbitration, not having done so for 30 years of doing business, the same attorney then incorporates using the same name and tacking an ink on.
Counsel, assuming everything you're saying is true and that there was questionable behavior on the other side, how can the court legally allow a judgment to be entered against a corporation that was not in existence at the time the arbitration agreement was entered into. Don't you have to take some further step now to make an allegation of piercing the corporate veil or alter ego in order for the judgment to be entered against the respondent in this matter?
Thank you. Respectfully, I don't think so, and there are two reasons why. First, the basis on appeal here is very, very limited. And all of these arguments were already considered not once, not twice, but 3 times by the lower court. First on, bless you, first on the original petition, second on the re-argument, and then we actually made a sanctions motion, which the court actually said there might be consideration for CGS to bring an action under debtor-creditor law or for fraud based on what was seeming to be an obvious avoidance of the award. So these are not new issues. These are issues that have been considered 3 times, and the basis that this court can look at for confirming under Article 75 is very, very limited. And this,
but again, legally, they were not in existence at the time the arbitration agreement was entered into. And if they're not in existence, just as a purely legal matter, how can they be a party to the arbitration agreement?
because what they did was incorporate an entity that basically had the award issued against it already. That's what they did.
But isn't your obligation at that point to bring some kind of proceeding to establish that there's an alter ego instead of just proceeding against the corporation that didn't exist when the arbitration occurred?
Well, not exactly, because the award is issued against RS Custom Woodworking. And when we go and file the application, and there's only one entity that appears anywhere in the state records that says RS Custom Woodworking, Inc., that was an indication that there was the right entity being sued. And this is what the lower...
But it hadn't existed at the time of the arbitration, so it couldn't be the right entity in the legal sense.
Well, RS is the one that participated in the arbitration. And then the award was issued against RS. And then the judgment was...
But you told us just a few moments ago that Dolce did put in an affidavit at the arbitration as to the actual name of the corporation that was doing business.
What I said was Ron Dolce, the individual. And it was the very first time that anyone on CJS's side ever heard that name, Dolce Custom
But
Woodworking.
what's the difference? You know about it before you're entering judgment.
Because that wasn't actually what was alerted to. And in fact, when you look at the award itself does not mention Dolce anywhere. The award, not only the initial award, but the final award, nowhere mentions Dolce. It is against specifically RS Custom Woodworking. And so there is no fair notice that CJS had that what the party that it was really dealing with was Dolce. And this gets into the point that we made, which is when you're dealing with agencies, and agencies of either undisclosed principals or partially disclosed principals, what happens is you have to find out who is responsible for the contract. And if anything, Dolce Custom Woodworking is the last entity that would be responsible here. Because if you look at the master service agreement, and that's in the record starting on page 45, the master service agreement was signed by Ron Dolce as president of RS Custom Woodworking. Dolce is mentioned nowhere in that agreement.
Thank you very much.
Thank you, Your Honors.
The next case is Epic W14 LLC.
May it please the court, my name is Tom Lambert. I represent the defendant, appellants, the guarantors. The court below found issues of fact, material issues of fact, which compelled the denial of the motion for summary judgment. The court said defendants have established discrepancies as to the amount owed under the guarantee, creating an issue of fact as to the amount of damages. Well, an element of the plaintiff...
I'm sorry, but that didn't preclude, the court only found summary judgment on liability. So a question of fact as to the amount of damages doesn't preclude an entry of summary judgment on liability.
Well, there's no liability unless there's proof of some money due. The plaintiff must prove that there is an underlying debt. And they didn't...
Well, I don't think there was a dispute.
The court didn't find...
But to the extent that there was a dispute about the amount of the underlying debt, the court wasn't varying between 0 and some other number. It was a small range of what the dispute was.
That's not, I don't believe that's correct, Judge. In other words, the question was whether there was any damages at all. And it's not a personal injury case. They didn't have any proof of rent that was due, no proof at all. That Exhibit J that they have is a disaster. It's filled with contradictions and things, and of course, the plaintiff could just testify in his affidavit, look, they owe that much rent. That's a prima facie case for rent right there, if he swears to that. But the truth, but then he says that, he said they owe $800,000 in rent, and then he says, see Exhibit J. So obviously, he doesn't have that figure in his head. He's saying, he's showing you that's the money they owe based on Exhibit J. Well, Exhibit J is filled with whole cloth. There's filled with contradictions. The balance carried forward is different from the balance on the last page. We go through that thoroughly in our brief. And that's true with regard, the court made statements
So,
also.
counsel, if I may, so you're challenging the finding that there's liability even though the guarantors pursuant to, what is it, paragraph 12, remained liable even if all payments had been made per the agreement?
No, there was no proof. The judge also found as a fact that that the plaintiff was in possession of information which it hadn't provided on discovery. And that under 3212 should have compelled the court below, 3212F, should have compelled the court to deny the motion for summary judgment right there. There was no proof of rent due by anywhere. The Exhibit J is a disaster. They don't have any proof of any rent due. So there's no money proved to be due under the guarantee. There's no underlying debt show. I want to mention one more
What's the
thing.
effect of the stipulations that you entered into in civil court?
Yes, let's look at that stipulation. Under the stipulation, in civil court at page 59.
Weren't you supposed to make payments on, wasn't there an agreement as to the amount that's due? You were supposed to make payments, a few payments are made,
Yes.
and then you stop paying.
Yes, no, this is what happened. There, in paragraphs 1 and 2 of that stipulation, there's a judgment issued and a warrant that canceled the tenancy. Then in paragraph 12 of the stipulation of settlement, the guarantee was modified. The original guarantee was superseded by a new guarantee that's contained in the stipulation of
The
settlement.
second stipulation.
What?
You enter into another
Yes,
stipulation.
the guarantors who weren't parties to the case where the stipulation of settlement were into, the guarantors signed that stipulation. They came on board.
Doesn't Walter and Lieberman sign the first stipulation?
Yeah, they all signed the first. What do you mean the first?
You had two stipulations in
They
civil
all
court.
signed both of them. There was an amendment to the stipulation, but the original stipulation says the guarantee is modified. It was superseded by the covenant, by the promise of the guarantee in the stipulation of settlement. Now, this is the point.
Counsel,
Then
counsel,
there was a failure of
Counsel.
consideration.
counsel. So you're jumping, though. So in 2016, the stipulation says that $865,000 is owed, right?
Yes, that was paid.
2000
They overpaid. They paid
2000
more than $3 million against that. That's history. That's shown in the record. There's no question about that. What isn't shown, so what I do want to point out in the record, which is critical since I have this time, is that there was a wrongful eviction. There was a failure of consideration for the guarantee that was made in the stipulation of settlement. The only thing that the
Did you make
guarantors...
the payments you were required to make under the stipulation? Did the tenant make the required payments?
I'm sorry that I don't hear you clearly.
Did you make the payments that were required under the stipulation?
I don't, yes, they were made more, the 800, well,
But didn't there reach a point that a payment was due and you didn't make the payment?
I'm not presenting their case for you. They paid they paid $3 million as against the $800,000 that was due at the time of the stipulation. What they owed or don't owe is not determined on this record. There's
Thank
nothing.
you, counsel. You have a minute for rebuttal. Thank you
Yes.
very much. Thank you.
Yes, thank you, but.
Sorry. May it please the court, my name is Stephen Sperber for the respondent.
So counsel, if I may,
Yes,
the only issue here is damages, right?
and that issue was adjudicated in a second motion that was subsequently made where an award of $1.9 million was entered. It's an unconditional.
Counsel maintains that the initial $865K, I think I have that number correct, yeah, that was paid.
Absolutely not true. There's a current rent provision in that stipulation, as often is when you give somebody a long time to pay the money. The rent was over $100,000 a month. This was a gym that took up a whole block in Union Square. They were in default for 30 months in a row. I had to send a notice of default, and ultimately they were evicted. And before they were evicted, there was an order to show cause before Judge Ramsour, who found that they still owed $842,000. And to hear counsel say there was a wrongful eviction, it's incredible to me that people could just say things like that. What happened was state tax locked them out for not paying taxes. And 2 weeks later, the city marshal came. And after this motion was decided, he deposed the marshal, and he knows very well that there was a legal eviction. And so what did he try to do? He tried to play cute. 2 days after the marshal came, he sends a surrender. He claims to cover his tracks. This is an unconditional guarantee. They didn't pay the rent. The eviction was proper, and there's currently a judgment now in excess of $2 million.
Counsel, what is your position with regard to counsel's statement that the issue of fact was whether whether the guarantee was from 0 to some other number, or whether it was a smaller number that there was a dispute about?
That's nowhere in the record, Judge. It's an unconditional guarantee.
But there still has to be an amount. What is your view of what the amount was at that?
We attached a rent history, and we had an affidavit. There's $1.9 million. But there was one issue of fact on the first motion. That issue of fact was there was a CR credit for $240,000. And Justice Cohn didn't quite get what that was initially. But later on in the second motion, it was explained when we got the judgment that that CR was for the drawing down of the letter of credit. It was a credit for the security. There was no payment made.
So that's the only dispute at this point on the motion?
That was no dispute because...
On the motion that's in front of us?
Yeah, that would be the only, but it's not a dispute because it was a credit for drawing down in the letter of credit. And so if there's no further questions, I respectfully submit that the decision of the court below should be affirmed.
Thank you very much.
Thank you.
Now, wait a minute, let's look at the record. At page 115 is their rent ledger. August 6, 2016 is when the stipulation of settlement was entered into with the $800,000 being acknowledged to be due. Let's look at all the payments that were made by the tenant according to their rent ledger after the stipulation of settlement. Begins on page 115. There's more than $3 million paid.
Didn't you already have a hearing according to opposing counsel?
What?
Didn't you already have a hearing now to ascertain how much actually was due of both sides?
No, there was
You didn't
no
have that
There
hearing?
was
So how
submission
did he get a judgment?
There was a submission of papers on a motion.
Okay, but a determination was made what the actual amount was due at this point.
Not that amount. That's an entirely different claim. That was based on an entirely different claim. First of all, the guarantors weren't party to the case. Second of all, the claim was entirely different than it is now. The claim that they're making now is not for the $800,000 that was acknowledged to be due under the stipulation of settlement. That's long since paid.
Okay, thank you very much. Counsel, thank you very much.
It was a failure.
Thank you.
Wrongful eviction.
Thank you. Thank you, counsel.
Page?
Counsel, thank you. Time's up. People versus William Gay.
Good morning, Your Honors. May it please the Court. I'm Jacob Loop of the Law Offices of Joel B. Rudin in association with the Office of the Appellate Defender. I represent the appellant, William Gay. The evidence in this case was legally insufficient, or at the very least was against the weight of the evidence. The prosecution's own star witness, Talena Simmons, proves that William Gay couldn't have committed this shooting. She testified that William Gay was here to her right, shooting victim Glenn Terrell was here to her left. And as she turned her head from Gay to Terrell, the shot was fired. Clearly, in the scenario, If Gay had been the one who shot Terrell, the gun would have to have gone off directly in front of her face. But she didn't testify to that. She said she didn't see the gun. She didn't see the shooting at all. She proves that he couldn't have been the shooter.
But hadn't she also had a lot to drink at that point, so that her testimony about exactly what happened couldn't necessarily be relied on in terms of whether she saw the shot?
She had a lot to drink, as did the other prosecution's star witness, Andrew Brown, two witnesses that the prosecution credits and put on the stand. In addition to that, the thing that we're talking about here is seeing a gun go off directly in front of her face, which presumably would be one thing you would remember regardless of how much you had to drink.
So we know that this case was built on circumstantial evidence. What about the testimony that, do you say tinnitus or tinnitus? Tinnitus, right? Would result if there was a gunshot in close proximity to a person's ear, and Ms. Simmons testified that she experienced significant ringing in her ears when the victim was shot.
Right, she testified she heard ringing in her ear. There's no question that Glenn Terrell was just to her left when the shot went off. It was the undisputed that the shot went in behind his head. So the most probable version of events, based on her testimony, is that somebody came up from behind Terrell, shot him in the back of the head. It was still very close to her under that scenario.
What do you do with Brown's testimony that he's outside the bar when he hears a gunshot and he sees the defendant standing over Terrell and holding a black object?
That doesn't meet the prosecution's burden of proving that Mr. Gay was the shooter, Your Honor. Both Brown and Simmons testified that the area was crowded. There were a lot of people there because the bar had just been closing. What Brown establishes at most, if you credit his identity...
I'm not suggesting that the prosecution meets its burden just with Brown's testimony, but when you put it in comment, when you combine it with the other testimony, they do meet their burden, do they not?
They don't, because the two star prosecution witnesses, one of them gave testimony that the gun had, under which the gun would have had to have gone off in front of her face, which she didn't see. And then Andrew Brown, at most, if you credit his identification, which you shouldn't because he twice failed to identify William Gay in photo arrays within 7 days of the shooting, but if you credit his identification, at most, he puts William Gay standing there where somebody's shot right next to him. He has a black object in his hand. Could be a cell phone, could be a beer bottle, a glove, anything. He establishes Gay's presence along with multiple other people who were right outside there in a bar in a position to shoot Glenn Terrell. What other evidence does the prosecution have in this case? There's no forensic evidence tying Mr. Gay to the shooting. The motive is extremely weak. And then you have a consciousness of guilt.
Is the motive weak?
I think it's incredible, Your Honor, that the motive, the supposed motive, was that Mr. Gay once hung out with Talena Simmons a month earlier. She didn't know his name. There's no testimony that it was a sexual encounter.
Didn't she testify that she spent the night with him?
She testified that she hung out with him one night. That was the testimony at trial.
That she spent the night with him and his roommate?
The testimony about this spending the night with the roommate and Mr. Gay was there, I believe, was only at the suppression hearing. But in any case, there was never any testimony that it was sexual in any way. She testified there was no relationship. He never asked her out again. And so the supposed motive here is that another man propositions her and he flies off.
Putting that aside, isn't it very compelling that Simmons said there was nobody else there? I mean, she testified that he was the only one who was there other than the victim.
Your Honor, that was...
Who is this other person if there was nobody else present?
Just to clarify, at the trial, there was absolutely no testimony that Gay was the only one there. That was the detective's testimony at the suppression hearing. Simmons didn't testify to that at the trial. And in fact, she testified the area was crowded and that Gay was with another person. Andrew Brown also testified that the area was crowded. There were multiple people in that area who could have committed the shooting. In addition to the weakness of the evidence, there were multiple errors in this trial that prejudiced William Gay. It easily could have caused the jury to convict, despite the weakness of the evidence. The one I was first getting to was the consciousness of guilt evidence. That was improperly admitted and could easily have caused the jury to convict despite the weakness of the evidence. It was very prejudicial for at least two reasons. First of all, it allowed the jury to learn that Mr. Gay was on a curfew. And while they weren't allowed to know he was on parole, surely they put two and two together, understood that he was on parole or probation or something similar. The second reason is that faced with the weakness of the consciousness of guilt evidence, the prosecutor falsely exaggerated that evidence in summation. He goes and tells the jury that when the warrant squad goes looking for a suspect, they knock very, very loudly, thus implying that he was fleeing, which
Thank you,
proves
counsel.
he
You
was
have
not.
time for rebuttal.
Thank you.
May it please the court, Matthew White for the people. Here's what defense counsel said at trial. I submit you should accept Talina Simmons' testimony. She knows him. She saw him. She kissed him. That's in his summation at T332. And why did defense counsel place defendant there? Because it was the centerpiece of his defense that defendant and the victim were face to face and the shot was towards the back of the head, and therefore the defendant could not have committed the crime. But that evidence or that position was countered by the testimony of the medical examiner who said that the position of the defendant and the complainant face to face was consistent with the shot towards the back of the head, and the autopsy showed that the shot had to be within arm's length. It was a stellate wound, and the gunpowder was found inside the head. There was no fouling or stippling outside the head, meaning that the discharge literally went into the victim's head, which also may be why Talina Simmons did not see it. Then the testimony of Andrew Brown was incredibly damning because Brown heard the shot, and not only does Brown see the defendant standing over the victim, he sees the victim fall to the ground, and then he sees the defendant standing over the victim. And again, the shot had to be fired from within arm's length, and Brown sees the guy with a dark object in his hand and a look of evil. Defendants conceitedly there, and the evidence of his guilt was
Did Brown get
overwhelming.
to see anybody next to the victim and the defendant
No,
after he heard the shot?
no, I don't believe there's any such testimony in the record.
And what about the testimony at trial that counsel referred to, that it was crowded, that there were a lot of people there?
Well, there were other people outside the bar, but in terms of other people being present at the doorway, it's Talina Simmons, the complainant, and the defendant. Shot had to be within arm's length because of the nature of the wound. Defendant's the only one there. And then what really kills him is you see Brown's testimony that defendant was standing over him with an object in his hand. And so it's clear the evidence of guilt was overwhelming. And defendant, again, was conceitedly there. As to the other points, I'm not sure if the court has any questions about them. I'm happy to rely on my brief. But if your honors have any questions, I'm obviously.
Any questions? Okay, thank you very much.
Thank you, your honors. I ask that you affirm.
Just because if you credit Andrew Brown's identification, which you shouldn't, all he does is put William Gay standing there. Somebody has been shot and fallen at his feet. The area is outside the bar.
But he says, he testifies that he sees the victim fall after he hears the shot, and the only person next to the victim is the defendant.
His testimony was not that the only person next to the victim was the defendant, but that he saw William Gay's, who he claimed was William Gay, standing over the victim. But he testified that it was crowded, and Talina Simmons testified that there were a lot of other people right there because the bar had just been closing. She also testified that William Gay was standing with another person. There were clearly other people right in the vicinity of that doorway. And Andrew Brown didn't see the gunshot. He wasn't looking at the time the shot was fired. Somebody could easily have come up, shot Terrell, and left. Andrew Gay stood there, looked down for 1 second, and then left. How does that make him guilty of shooting, the shooting?
Thank you very much.
Thank you, Your Honors.
The next case is Woodson versus Convent.
Good morning, Roger Sacker, Newman Ferrara. May it please the court. This court's J51 jurisprudence is pretty clear-cut at this juncture, so I'd like to spend my time highlighting 5 very quick points. First is this idea that damages stop accruing the moment you file a case. This has started to come up in a number of opinions, all of which appear to be authored by the...
This is a 37-apartment building, right?
Correct, Your Honor.
And this class action involves 13 apartments.
Correct.
Now, 9 of those 13 apartments were deregulated based on high rent, reaching high rent. And weren't 6 of those 9 apartments deregulated before J51 benefits were even received by the building?
Yes, Your Honor.
And how many apartments were deregulated after Roberts went into effect?
There was 1 apartment that was deregulated after Roberts. None of the apartments were re-registered until November of 2016, even after which...
Isn't that a significant fact? Because you started this action, whether it's November or December of 2017, but the landlord re-registered the apartments after being told by given guidance by DHCR as to re-register before this complaint was filed. Now, Supreme Court relied on Montero. In Montero, wasn't the re-registration after the filing of the complaint? Isn't that a significant factor when you consider a center for purposes of fraud?
No, couple of things. First, let's talk remember, they re-register, but they don't tell the tenants their rent stabilized until after we file. Re-registration means absolutely nothing unless you're telling people they're actually rent stabilized.
Were they charging the correct rent after they were
No, they registered with preferential rents and then used those preferential rents to take increases in excess of RGB increases. Contrary to DHCR, contrary to this court's Gersten opinion, we just saw this in AMPIM. I think it came out
How about
2 months
this
ago.
court's opinion in Austin from February of 2022, where they were fictitious leases, and we said that you cannot get fraud as a matter of law. You cannot prove fraud as a matter of law, even under the facts of that case.
Because in that case, there was a discrepancy. Both sides disputed whether or not the registrations were accurate. Here, they registered. We know they weren't accurate. There's no contention otherwise that they registered with preferential rents and then
Your position that Montero is controlling in this case?
Absolutely. Remember, it's my case.
Tell me exactly why it's controlling.
Because Montero says you cannot take tax benefits and fail to re-register after Gersten. March 2012. Hess is also controlling. Hess is right on point, and it says Gridley, which my adversary is going to rely on, Gridley isn't opposite when you fail to register. This is exactly what these people did. This is AMPIM. They knew. That's where Sienter is. They say in AMPIM, this court says, if you take the tax benefits, you know your requirements.
You say that Montero is controlling, but Montero didn't find fraud as a matter of law. It said you can seek to establish fraud. Here, Supreme Court, and what you're advocating for is that we find fraud as a matter of law. So even if you follow Montero, it doesn't take you to finding fraud as a matter of law.
Montero says this is the conduct that is the hallmarks of fraud. They say hallmarks. And the difference between...
Let me ask you the follow-up question that's connected to that. You can ask them both together. Are there any factual disputes about the factors articulated in Montero as applied to this case? Or are they clear from the record?
The only difference, there's 2 differences between this and Montero. Difference number 1, in Montero, it was the landlord's motion for summary judgment. It was not our motion for summary judgment that was being appealed. That's difference number 1. Court still said hallmarks of fraud. Difference number 2 is in Montero, the landlord deregulated after Roberts. But it also failed to re-register after this court said re-registration, March 2012, prompt re-registration.
Well, what about the fact in Montera, there's the re-registration after the complaint is filed? Here, there's a re-registration a year before the complaint is filed.
And a year after DHCR said to re-register, and the re-registration with
It
fraudulent.
was 10 or 11 months.
11 months, okay, a difference of a month. The re-registrations were still utilizing preferential rents.
So what
They
we
still
said,
kept
so
telling
what
the
we
tenants
said
they were
in
deregulated.
so what we said in Montera, for these reasons, we find that the apartment history beyond the 4-year look-back period may be reviewed to determine whether fraud occurred.
And that's what we got here. You have a landlord that was telling tenants, even after being advised by DHCR to re-register, that they were free market tenants. They enshrined an illegal rent in the rent history by failing to follow Gersten. It's the
Thank you,
same
and you
thing.
have 2 minutes for rebuttal.
You got it. Thank you, Your Honor.
Thank you.
Good morning, Your Honors. Magda Cruz for the respondent, cross-appellant, Convent 1 and Chestnut Holdings. First of
So
all,
one of the things that the tenants charge here is that you claimed apartment improvements which never took place. How do you deal with that issue in terms of whether there's been fraud here?
well, first of all, Your Honor, the claim is not made by any specific tenant. There is not even an allegation of fraud in the complaint. The complaint is not verified, and not a single affidavit exists. So are we to take that allegation of alleged improper apartment improvements by simply counsel's chart? That is where it appears in a chart, Your Honor, in a summary form.
Is your point as to that the burden of proof on this issue was on the tenants, and they presented no proof on that issue?
They presented no proof, and moreover, Your Honor, even assuming arguendo, that there might have been apartment improvements increases that exceeded, which I completely dispute, but I just want to, for purposes of your question, pose it as a hypothetical, that would not be fraud, Your Honor. Judge, the justices of the Court of Appeals.
But ultimately, isn't it the appellant's position that they don't need to show fraud because under Rent Stabilization Code 2525.3d, any violation of the Rent Stabilization Code provides them with the basis to get the default formula?
So, Your Honor, are we saying that the Rent Stabilization Code amendments in 2014 somehow trump what the Court of Appeals says is fraud for purposes of these J51 deregulation cases?
Is there
Counsel,
any
why
case
is
which
this
has applied this catch-all provision to take you to the default formula just based upon any violation of the pursuant to 2525.3d? Is there any case which has ever done that?
Not one, Your Honor, not one. And yet there's numerous cases in court, including the Court of Appeals, that had said this is what the elements of fraud are necessary for the default formula.
How are you grappling with Montera and the fact that the whole point of Montera, and I know there was dissent, but the whole point of the case is that this is not a typical pre-Roberts situation, because even after Roberts came out and even after it was clear it was retroactive, there's still indicia of activity by the landlord not acknowledging the updated state of the law, and although some of the apartments were registered, still not charging appropriate rents for years after Roberts and its progeny was decided.
Okay. So the main difference between our case and the Montera case, the most critical one, is that in our case, virtually all of the apartments were deregulated before Roberts. Therefore,
why does that change that? Because it's clear, once Roberts was decided, it's completely clear that even if they were deregulated before, they come back into regulated status once they get the J51. So how can the landlord ignore what's clear law and argue that there's not indicia of fraud based on ignoring what's been clear law for years?
Respectfully, Your Honor, I respectfully dispute that it was clear law. In fact, it was so confusing and so uncertain up until 2020 when Regina was decided. Owners did not know.
What does the Court of Appeals say in Regina about finding fraud on these post-Roberts re-registrations?
Well, in Regina, of course, all of the apartments related, with the exception of one in the Taylor case, all related to pre-Roberts deregulations. But in Regina, the Court of Appeals made a general statement of what is fraud and what are the elements of fraud for purposes of determining the default formula applying to recalculating the legal rents of these types of apartments that were deregulated in the aftermath of Roberts, and in fact, that followed Roberts for a number of years in not knowing what the legal rents were, how to re-register. In fact, the
When did
state agency...
DHCR first give guidance as to how to re-register?
2016, Your Honor.
But your client at that point still didn't re-register, and even when they did re-register, they didn't notify the tenants, correct?
No, Your Honor. My client re-registered within the same year that
But not
initiative.
within
I wouldn't
the
say
year.
that
I'm sorry, you're saying within the year. I said 11 months. So
Your Honor,
11 months is a long time, isn't
Your
it?
Honor, it's not a long time. When you have to figure out the rental histories, you have to figure out...
But they didn't then notify the tenants of the re-registration, correct?
I dispute that, and there's nothing in the record that
Is there anything in the record that shows that they did notify the tenants of the re-registration?
I have two client affidavits in the record. They
Who has the
claim...
burden of proof in establishing fraud?
It is certainly upon the tenants.
Is there a single affidavit from any tenant in the record?
Not one, Your Honor, not one. And therefore, it is impossible to say that the tenants were not informed of what their status was.
And how do you establish reliance for purposes of fraud?
For purposes of that element of reliance, in this context, you would have to say that the tenants somehow made some adverse decision to their personal interests, such as moving out, such as changing their rental situation based on some misrepresentation of fact, knowing misrepresentation of fact.
Okay.
There is no such reliance here. In fact, again, I go back to the indisputable fact that there is not a single affidavit here by any tenant.
Thank you very much. You'll have 2 minutes for rebuttal.
Thank you.
Okay, there were a lot of points there. Let's take them in turn. Record 230 is where the landlord itself represents that it did not perform any individual apartment improvements. So this contention that we now have to prove that they were right is ridiculous. They admitted it. Second, let's talk about reliance. Ackerman
How does
v.
that
Price.
jibe with the need to show reliance?
Let's hit it, Your Honor. Reliance, when it's a material fact, this is Ackerman v. Price Waterhouse. Reliance is presumed because it's a material fact. Let's talk about we heard this representation that the tenants were were somehow required to be told that they were rent stabilized. Right here. This is 2017, after they re-registered the apartment. Record page 626 is just an example. January 25th, 2017. Non-stabilized extension agreement, renewal lease not subject to rent regulation. That is illegal. After DHCR told them, after they re-register, they come in and they are providing tenants with non-stabilized leases.
So
Finally,
that's the opposite of them giving notice of re-registration. They're actually...
Thank you, Justice Gesbert. Thank you. Yes, exactly. They are continuing to deceive the tenant.
And yet does Austin, which we decided just several months ago, in which their fictitious leases filed, and we refuse to find fraud as a matter of law.
And there is Hess, and there is Ampin, and there is Montera, and there is Kriesler, and there is Nolte, all on the other side.
Montera, the registrations take place after the complaint is filed.
But what's the difference if they're not telling the tenants they're rent stabilized?
It goes to the question of whether this fraud is a matter of law.
Well, that's what
Is there any case that you have which has applied 2525.3 to give you this catch-all getting to the default formula? Is there any case which has applied that provision of the rent stabilization code
as far as I know,
you're advocating for here?
As far as I know, we've never needed to apply it. because it's only been around since 2014, right? It takes a long time. There's only a few folks who are even practicing in this area of law. Nobody's ever really had to bring it forward because it's always fraud that taints the rent on the base date.
Thank you very much,
Thank you.
Counsel.
Simply stated, this case falls squarely under the Regina rubric of non-fraudulent deregulations. And
How do
that,
you deal with the fact that that your client sent notices to the tenants after re-registering saying that they were not rent stabilized?
yes, Your Honor, I completely concede that there were a few,
Well,
not
but
a
isn't
broad.
isn't that an you just said there were no indicia, I thought you
Well,
said. There
those
are no,
were renewal
excuse me, I
leases.
thought you just said there were no indicia of fraud. Isn't the landlord sending notices to tenants after re-registering stating that the tenants were not subject to rent stabilization fraudulent?
No, because
Really?
they were mistakes, Your Honor, and we
Well, I don't
concede that they
understand,
were
how do we
mistakes.
decide, how do we distinguish between a mistake, which is okay, and an action which, somebody had to decide to do that. How can you,
Because-
excuse me, how can you decide that that's a mistake and not a fraudulent act?
Because, in fact, the apartments were registered with DHCR as rent stabilized.
If the tenants don't know that, what good does that do them?
Presumably, the tenants were served with the notices of registration.
No,
And
we
number,
don't presume that. How do you, excuse me, you're relying on the re-registration as significant. But if you don't, but you don't seem to have any proof that you advised anyone of that, but you want us to presume that the tenants were advised of that. Why should we presume that if you don't have proof of it?
because the vast majority of these deregulated apartments, the tenants were given rent-stabilized leases. They are in the record. I can provide you with those records. But in fact, what you are referring to are a few isolated renewal leases that were issued after the registration, after the apartments were registered as rent stabilized. A few, Your Honor, does not make a fraudulent scheme.
Is that question really determinative as whether there's fraud here as a matter of law?
No.
Or whether it's an issue which is to be determined?
Exactly, exactly. Respectfully, I ask that the lower court's decision be affirmed in all aspects, with the exception of the finding of fraud with respect to 3 apartments, which the court did so.
Thank you.
I know your time is up, if I could just ask. But why, the issue of whether if there are overcharges to be paid, why does it end with the date of the complaint? Why wouldn't the court be in a position to make an award which is up to the date of the decision?
Right. The court did so based on its reading of CPLR 213A and Rent Stabilization Law 26516, which says that no award or calculation of an award is to be made with respect to the overcharges for the 4-year period. So the court was following the statutory language.
Doesn't that lead to an irrational result that the tenants have to then bring a new action to recover the overcharges during the period that the lawsuit is pending? Why is that a rational result for the tenants, the landlord, or the court system?
Because not in all aspects is that appropriate. In this case, it is not appropriate, especially where the tenants waited so many years beyond the time that they, if the owner allegedly knew that the apartments were not properly deregulated, the tenants should be presumed as well. So I think that the court's analysis had to do with whether what the statute said and whether it was appropriate under the factual circumstances of this case. Plus, the court was relying on precedent that had already also held that the recovery period is 4 years prior to the bringing of the complaint.
Thank you very much.
Thank you.
The next case is GSCP Edgemark, and I am recused on that matter.
So I just want to let you know that in the event that there's a tie vote, a 5th judge will be vouched in.
Very good. I had brought a couple of quarters you could use to flip, if that would be helpful. But good morning, David Cole from Texas. Thank you for admitting me for purposes of this proceeding. I wanted to use my time this morning to focus on one issue, one cluster of issues that I believe cuts through all the points raised in this appeal. It is the differences, the material differences between what constitutes a work product waiver under this state's law, New York's law, and those principles under Pennsylvania law, where there was some earlier litigation about that subject in this case. There are a lot of cases cited by both sides in the briefing about the elements of New York law in this area. Big picture, in my time today, I think there are two related factors that animate those cases. One is the degree of confidentiality protection that is made in connection with a disclosure of information. The second is the degree of voluntariness. And when you look at the cases in New York on this point, they all look to those two issues in some fashion, and they all weigh them in some way to decide if there has been a waiver of work product protection, which, by the way, there's no dispute that the underlying document here is work product, but otherwise be protected.
Why isn't it appropriate for the court, the court applied Pennsylvania law, and you're suggesting that we should apply New York law. Why wasn't it entirely appropriate in this event to apply Pennsylvania law, since it's our practice to normally apply the law of the place where the evidence in question will be introduced?
Well, that's here.
Or the location of the discovery proceeding.
Right, the proceeding is, the court is, the case where this matter is going forward is here in New York.
The place where the discovery ruling was originally made was Pennsylvania. Why shouldn't we apply their law?
That's because the question of waiver is the question for this forum, because the question before this court is what testimony will be acceptable at the trial of the case, what evidence may be used by experts, so on and so forth. Those are forum issues, waiver, rules of evidence, that sort of thing. And this court and the court of...
So you're saying that there's a do-over, basically, that when the case is litigated in New York, what happens in Pennsylvania is irrelevant because both parties start afresh?
No, I'm saying that in New York, those who would try to introduce this evidence, we examine the laws of New York as the New York forum as to what is admissible and what is not admissible. That can involve events that take place out of state.
I'm going to piggyback on what my colleague just said. Why doesn't collateral estoppel apply?
Because the law is different. The Pennsylvania court looked at Pennsylvania law, applied it, I believe.
But once it loses its privilege in Pennsylvania, shouldn't its privilege just be lost?
And there are cases...
It's going to be privileged in New York and not privileged in Pennsylvania?
Yes, there are cases in Pennsylvania that say exactly what you just said, Your Honor, that once you release the document, it's gone and that's that. That's not New York law. New York law looks at the two factors I was talking about, the degree of confidentiality protection, the degree of voluntariness. Those are different.
Okay, so we get back to, isn't there collateral estoppel anyhow? You had your opportunity, you had it in Pennsylvania, you lost.
We litigated under Pennsylvania law. The judge applied Pennsylvania law in that proceeding. Now we are here in a different forum with different rules, different policies. This court's AMBAC case says the routine rule for this kind of admissibility decision, waiver decision, is to apply the law of the forum. It in turn echoes Court of Appeals authority on that point. So now that we are in a new forum, there are new rules of evidence. This is one of those rules, the rules of waiver, and we take a look at it under the New York framework, which, by the way, as to confidentiality, not discussed in the Pennsylvania opinion because they said it wasn't relevant under their law if it wasn't an inadvertent disclosure. Here, we cite a statute that makes it a crime in Pennsylvania if the people we disclosed it to leak it to the public. It's Pennsylvania Revised Statute 2145. It says anyone with that agency that releases our document shall be removed from office. That is extraordinary confidentiality protection in the forum, in the place where we made that disclosure.
Counsel, under your analysis, if there was litigation in other states, so long as it was a different state with different rules, there would be no collateral estoppel as to the disclosure of the landslide report.
If there was a material difference in the laws, I think there's a serious question there would be collateral estoppel. And there is, there will also have to be...
It's the same document.
That's right.
That was disclosed to the Pennsylvania DEP without any objection to the subpoena.
Well, but it was done pursuant to us invoking the protections of this Pennsylvania Environmental Information Law, which didn't get any weight in the Pennsylvania opinion. The judge there said confidentiality
Did
isn't
you appeal
relevant.
that if you didn't like the?
We appealed it,
PA?
and the case settled on appeal. Where that leaves us in terms of finality is frankly unsettled under Pennsylvania law. I hear their argument. There's no case that says the case has collateral estoppel effect at that point, though. But I think the real issue is identicality. Confidentiality, I think, is dispositive under this state's law.
Counselor, your time, thank you.
Good morning, Your Honors, and may it please the Court. Emil Kleinhaus from Wachtell, Lipton, Rosen, and Katz on behalf of the respondents. Your Honor, we believe that the result will be the same under either law, but court below, Justice Cohen, was perfectly correct to apply Pennsylvania law. This was a production by a Pennsylvania company to a Pennsylvania regulator under a Pennsylvania statute, under a Pennsylvania regulatory regime.
But if it would be privileged in New York, and this being litigated in New York, why shouldn't New York law apply to it?
Well, a couple of reasons. First of all, ETC's own argument on privilege turns entirely on Pennsylvania law. The argument, and you heard it today, Your Honor, is that under Pennsylvania law, there was no ability to object to this subpoena. This was a compelled production. But the Pennsylvania court addressed that exact argument. The court held, and I quote, ETC retained the right under Pennsylvania law to object to the subpoenas on the basis that the root cause reports were protected by the work product doctrine. So this is necessarily Pennsylvania law, because the crux of the issue is, what does the Pennsylvania regulation require in producing documents to a Pennsylvania regulator, and when is there a waiver under that Pennsylvania regulatory regime? Even as ETC frames it, the issue is one of Pennsylvania law, and separate from that, Your Honor, under the court's AMBAC precedent, the court looked at a similar situation, a Wisconsin regulator. There was a Wisconsin regulatory regime. It was an insurance instead of environmental regime, and there the court said that when you're talking about a regulatory regime in another state, and there's a production to a regulator, you look at that state's law. And likewise here, it was a production to a Pennsylvania regulator under a Pennsylvania statute. I think the case is even stronger here, because what we're talking about is Pennsylvania real property, harm to the physical environment in Pennsylvania. So it's really not possible to decide the issue presented here without looking at Pennsylvania law, because that was the law under which the production was made, and ETC's own argument is focused on Pennsylvania law. So under AMBAC and under the...
Your adversary says, well, this was supposed to be confidential. This was supposed to be confidential between ETC and the DEP, and in New York, there's stronger protections. So we want to go with what New York says.
A couple of answers, Your Honor. I mean, first of all, as Justice Cohen said, and I think he said this almost in these words, there's a difference between privilege and confidentiality. Those are different things. The other point is, as to confidentiality, this production was made to several regulators, the DEP, the PUC, the Attorney General, and it was then publicly used. It's on the website of the PUC, a grand jury in Pennsylvania. Anybody could go do a Google search and find references and descriptions of these reports that were produced. So whatever confidentiality protection ETC wanted to have, they made this production to regulators with no meaningful restriction on use, because the regulators turned it around and publicly cited and quoted these very reports in their public settlements with ETC. So the Pennsylvania court, applying Pennsylvania law, which is applicable here, addressed this exact question on confidentiality.
Given that this motion is, that this information is essentially in the public domain and anybody can access it online, what is the value to them of a protective order?
Well, I want to be very precise and factually correct. What's online is a PUC settlement and a grand jury indictment with references and some description. The actual documents themselves, as far as I know, are not online. Those were produced after Justice Cohen compelled production in this proceeding, and they were separately required to be produced in Pennsylvania and multiple proceedings. I mean, this exact argument was made by Energy Transfer multiple times in Pennsylvania and lost every single time. and ultimately the documents were produced to civil litigants in Pennsylvania at all, as well, consistent with Pennsylvania law as determined by multiple Pennsylvania courts. So we have a final order in Pennsylvania. On the issue of finality, Pennsylvania looks at the restatement of judgments, and in the context of collateral estoppel, what the restatement of judgment says is that you have finality when you have a sufficiently firm order. Here you had a sufficiently firm order. Judge Ward has this extensive opinion in the record. ETC appealed from that extensive opinion, and then ETC settled. And Pennsylvania law is absolutely clear. It's a case called Schaefer, that when you appeal from an order under Pennsylvania law, that doesn't strip the underlying order of collateral estoppel effect. As Justice Cohen held, that order is final and entitled to deference.
Have there been any other orders in Pennsylvania giving the first order collateral estoppel effect?
I don't know about collateral, whether the second order, the second order applied collateral estoppel, but a second Pennsylvania judge relied on the first Pennsylvania decision to require production. So there were two Pennsylvania decisions, one by Judge Ward, and then in a subsequent case, a different Pennsylvania judge made the same finding. I don't know whether that second judge applied doctrine of collateral estoppel or simply reached the same result.
Was that decision appealed?
I believe it was, and the appeal was dismissed in Pennsylvania.
Okay.
Thank you.
Thank you.
Briefly to choice of law and this court's opinion in AMBAC, because that's obviously a threshold question as to what state's law we turn to. It acknowledges, as I've noted earlier, the routine rule in privilege disputes such as this one is the law of the forum, quoting extensive New York law on the subject. And the party in that case, yes, it was a regulator asserting a privilege that it had under another state's law, but the Wisconsin entity in that case was a party here. It was here. It was part of the law that created it, was that statute. If in this case, today, we had the Pennsylvania regulator being sued somehow or bringing the case here in New York for some reason, then AMBAC might speak to that. You'd be looking at the very definition of who the party was. But that's not the situation we have. This is no different than any other privilege dispute or waiver dispute where events outside of the state have some bearing on what is relevant as a matter of law.
So, counsel, your adversary says that the report was referenced online by DEP. What does that do to your confidentiality argument?
If the full report's on there, I'll be very interested to see it, because the DA in Pennsylvania...
I don't know that he said the full report. He said reference.
There are references to it. I don't doubt that there are. But the report itself, not every word in a document protected by work product is work product. The privilege stuff, I believe to be maintained in confidence to this day, and I don't believe they've cited anything in their briefing to the contrary of that.
Thank you. Thank you both.
The next case is D'Ambruzzo versus Port Authority.
Good morning, Bernadette Panzella, together with Robert Schacht, who's my son and downstairs, because he was not allowed in. We represent Joseph D'Ambrosio, the injured worker, and his wife, Stephanie D'Ambrosio. We're here because we have two orders that we appealed. The first order denied summary judgment to the plaintiff worker who was injured on 2/19/2019 because the trial court found that the fall of between 15 to 18 inches was insufficient. So I'm here today to talk briefly about the legislative intent of 240. It is very clear.
I would appreciate if you would address the other issue, which is whether or not we should consider the video which your client had from 2 days after the accident but was not produced to opposing counsel for a long time and was the basis for this motion made even longer after that. So why should we consider that on this record?
Your Honor, that was the second order appeal, the denial
Yes,
of
I know.
the denial of
I'm
the
asking you
renewal.
to address that.
Because I think that Joseph D'Ambrosio met all the conditions that are required for renewal. We put the notice of motion.
Counsel, how can there be a reasonable justification for the failure to produce the video when it's undisputed that the plaintiff was in the possession of the video for a year and a half before the initial summary judgment was made, and even if he couldn't figure out how to extract it from his phone, he could have given the phone to his attorneys or notified his attorneys, but he did absolutely nothing and never provided any explanation for why he didn't produce this earlier. How can that fit into a reasonable justification?
I believe that it fits into a reasonable justification, Your Honor, because this was not top of mind for a man who by that point had already gone through a number of surgeries, including having his forearm sawed surgically so that the non-union of his ulnar could be addressed, which it has still not been.
Where is his state of mind addressed in the record? I didn't see that.
Well, Your Honor, he moved from one phone to the other, and he did not inform counsel that he even had this.
But counsel, the point is there has to be a reasonable justification, and the papers are silent as to any justification, much less a reasonable justification. So to say, well, he was injured is the reasonable justification. Every plaintiff who has a labor law case is obviously injured. There has to be something more to show a reasonable or any justification. So we need to know what that is.
Well, Your Honor.
And not only did he not move for a year and a half or produce it a year and a half before, but the renewal motion was not made till over a year later.
Your Honor, I have to rely on the papers with respect to Mr. D'Ambrosio's affidavit because I believe that he says in his affidavit that he didn't know that it could be moved from the Android phone to his iPhone, and he gave it no thought. When he discussed it with counsel without revealing any attorney-client privilege, we said, we'll try to do it, and that's what happened. We then got the video.
What does that mean? What does that mean for the standard that you have to show? Renewal is not for the taking. There's some showings that have to be made, and I understand that he didn't, but how can we reverse the judge below who decided that there was no justification?
Okay. Well, Your Honor, the case law that I have cited in the brief on the second order appealed states very clearly that even cases where there was a motion to vacate a default, there were no affidavits, the court accepted that as an excuse, took it as a renewal. I mean, we're supposed to be involved in the search for the truth. So what I'm saying is that if the video can resolve an issue that the trial court, that the motion court brought up, the motion court says...
Well, counsel, I assume what you're referring to, although they're not using the words, is that there is an interest of justice exception. So if that's what you're arguing, why is this a case where the interest of justice exception should be utilized where there's no excuse provided? And sometimes I know interest of justice is used where a witness couldn't be located or there's some reason given why it wasn't turned over earlier, but there's no reason here.
Your Honor, there's a case out of this court where there was, in addition to there was a change of venue case, and the plaintiff didn't even put in the basis for the change of venue, and this court said, well, that was okay.
Does the interest of justice question, is it affected by the fact that it's not like you're out of court, it just means you're not getting summary judgment. The issue remains in the case.
Well, that's summary judgment, Your Honor, most respectfully on
It's not like you're out of court because of this.
Your Honor, that's on 241-6 that we're talking about right now. I would like to focus my argument.
Your time's up, actually, but you'll have a minute for rebuttal. Thank you.
Good morning. Christian Gannon, Siegel McCambridge on behalf of the respondents. I think the court's questions basically centered on what the issue is here. Plaintiff did not come up with any reasonable justification as to why this video was not turned over.
Well, counsel, why shouldn't it be allowed in the interest of justice?
Well, Your Honor, I think...
Especially because what it showed so clearly was that the ramp was not nailed down.
No, actually, Your Honor, what Justice Suarez said is that he would, even if he considered the video, that the video was taken 2 days after the incident, so it's not dispositive of the fact that whether it was nailed down the day of the incident or not. And this video is still in the case in the sense that I anticipate plaintiff will try to use this video at trial. Defendants will then try to preclude it as a post-incident representation and not an accurate depiction of the plywood
This is
itself.
strong evidence against you, but it's subject to a defense of, well, it wasn't nailed down 2 days later, but at the time it was.
Yes, and Your Honor, actually, there's an affidavit.
I mean, even on summary judgment, that would be an issue. Had you had the video, that would have been, you could have defended against it with seeking to present evidence that on the day of the accident, the situation was different.
Correct. Right, and we didn't have that video until well after it was actually taken. And there was affidavits.
You had it at the time of plaintiff's deposition.
Oh, I used it at plaintiff's deposition. So I'm not claiming that it wasn't used in the case. I'm just saying it's not a sufficient justification or reasonable justification to grant a motion to renew. And
Is there any prejudice here?
I don't think prejudice.
Your clients? I'm asking you off the top of my head.
No, there's no prejudice, and I don't think prejudice is a standard anyway. It's really whether or not there's a reasonable justification why they didn't have the video in the first place. And it's, as I said, it's still in the case. We're going to battle this down the road. The plaintiff is not out of court. There's not, the case was not dismissed. These are all issues that are going to come up in the trial court as we go forward in the case.
Thank you very much.
Thank you.
Your Honor, respectfully, I would like to have an opportunity to discuss the first order appealed, which I didn't have a chance to do. The legislature, the 240 legislative intent is very clear. Since 1969, reiterated by the Court of Appeals, reiterated by many cases cited in my brief in this court, that the labor law does not say that any specific amount or distance is required. There is, just like there's no chart that says this injury is worth that much, there is nothing that is limiting in the statute in the labor law statute 240. This case is exactly on point with Greco. The Greco case, there was a piece of wood that was placed as a temporary path. It shifted, and the plaintiff fell through, because it shifted, in between an open area of the beams. Here, there's 2 pieces of plywood, another piece of plywood on top. As Your Honors have already mentioned, this was not secured in any way, shape, or form.
Okay, counsel, your time is up. We are familiar with the record. We're familiar with the argument. We have carefully looked at the papers. Thank you. Thank you very much.
Thank you, Your Honors. And best wishes for a peaceful holiday season. Even in these times, we have some things to be hopeful and thankful about.
Thank you.
The next case is Breslin versus Macy's.
Good morning, Your Honors. Barry Weiss for the appellant. This case is nothing more than a simple fall off of a defective ladder. Defendants are attempting to raise the sole proximate cause defense. The lower court was incorrect in the decision that they were able to do it on the 240 matter. They credited, the lower court incorrectly credited the testimony of plaintiff supervisor.
Well, counsel, if we accept the testimony of the foreman that it happened the way he says it happened, why wouldn't that raise an issue of fact as to whether he was a sole proximate cause? That if he really did go to the dumpster, pull it out from the dumpster after he told him not to use it, why wouldn't that be a sole proximate cause argument?
Well, first of all, Your Honor, they should never have credited the testimony because obviously his deposition testimony was entirely self-contradictory. This is one of those situations where credibility should be resolved as a matter of law. Quite frankly, his testimony is outrageous, and it's in direct conflict with his report that he made as his supervisor the day
But didn't he say in both? I mean, there was a difference in terms of how long he said the dumpster from the ladder, but aren't both versions consistent in the terms of the basic position that the plaintiff went to the dumpster and took out the ladder that he was specifically told not to use. Doesn't he say that in both of his versions?
Well, I guess that, well, he said in one, the big thing, he did say that, I guess, in both of those versions. One, he was clear in his deposition, which I want to point out was made after the
Sign all
summer.
of those reports?
I'm sorry, Your Honor?
Did he sign all of those reports?
He signed those previous, he probably signed those previous
There were
statements.
3 reports, weren't there?
I'm sorry, Your Honor?
There were 3 reports that you're talking about.
There were
weren't
2. There was an incident report that he made as the supervisor, and then after the litigation was commenced.
There's a workman's comp report, isn't there also?
I'm sorry, Your Honor?
Is there also a workman's comp report?
I believe that there is a C2 and workers' comp report. I want to point out, in none of those early reports made at the beginning was any type of behavior the plaintiff was alleged by his supervisor.
So I want to interrupt you to go to the other issue, which is the 200 common law negligence claim.
Right.
And I specifically want you to focus on whether this is a means and methods case or whether it's a dangerous condition case, because depending on what standard we use, it may result in a different outcome. What is your argument with respect to that?
Well, clearly, Your Honor, if you're going to credit the testimony of Mr. Koch, his supervisor in the case, of course, Mr. Breslin has a totally different position. Mr. Koch says the general contractor stepped on this ladder, creating the dangerous conditions.
The ladder is a tool of the job, isn't it?
I'm sorry, Your Honor?
The ladder is a tool of the job, isn't it?
The ladder, of course, is a tool of the job, but it was, forget the fact, putting aside for the fact that it was an aluminum ladder that by all accounts was in good working condition at the beginning, the acts of the general contractor, this gentleman, Steve, in stomping on the ladder but not rendering it completely disabled from the workplace, all right, created a dangerous condition of one of the tools of the job.
Why does that take that out of the means and methods? Because I guess it's part of how you look at it, but it was his choice, the worker, which ladder to use for the work. So isn't there an argument then if it's that he chose the ladder, that it's a means and method rather than a dangerous condition?
I don't agree with that, Your Honor. Number one, he didn't choose.
No, I'm asking a question. I'm not telling you.
No, but I don't think so, Your Honor. I think it's a dangerous condition case or a hybrid case between the two, which either.
You mean a tool becomes a condition of the premises?
Well, if the tool is dangerous, Your Honor, if it's rendered dangerous by the general contractor in the case, it should be a dangerous condition.
So we have testimony that the aluminum ladders should not be used, period, because there's a problem with electricity, right? With their serving as a conduit for electricity. So is that, first of all, is that the dangerous condition? Second of all, is the testimony that the ladder was bent and tossed into a garbage pile. Is that the dangerous condition, or is the dangerous condition attributable to the plaintiff who allegedly pulled out a crooked ladder and got on top of it? Is that the dangerous condition? Where does it?
Well, again, the thing of it here is obviously the plaintiff testified that there was nothing wrong with that ladder, albeit it was aluminum ladder.
Right.
But other than if it was the dangerous condition, the plaintiff there's no actual evidence in the case really that from the defendant Koch that the ladder was openly and apparent dangerous to begin with. His testimony lacks on that matter. Is that the plaintiff, even if you want to agree, which we don't, that the plaintiff pulled out the ladder from the trash, there's no evidence in the case that the ladder was defective, that he did it. And
Thank you. You have time for rebuttal.
Okay.
If it may please the court, Nitin Sain from Kennedy's, CMK, on behalf of the respondent.
You represent Buck.
I apologize, Your Honor.
You represent Buck.
Yes, Your Honor.
So normally, Buck would not be liable for the means and methods of the job unless they were in control of it. But here, with the evidence, whether it's true or not will be for trial, but that Steve bent this ladder, definitely making it even more dangerous than it may have been before, Isn't this a situation where even though the ladder is a means and methods of the job, because the ladder is a tool of the job, that Buck is potentially liable for that under 241-6 if their employee did this to the ladder?
2 points on that, Your Honor. First, the record does not speak to who the Steve is. There was a statement made that he was associated with Buck, but that has never been proven by anyone with any record. Second, the issue comes down
Yeah, but
to...
isn't that enough to defeat summary judgment?
No, Your Honor, because the superseding actions of the plaintiff would be
Isn't that
what needs
only
to be
though if we
focused on.
believe the story that plaintiff went and got the ladder from the dumpster, which we don't know if that's true or not?
Well, if you're going to give the version of Steve bent the ladder, then that would be...
What
he
about a
took out
version Steve bent the ladder and then the ladder just ended up on the work site again somehow?
It didn't, that is, the record is, the testimony is, it was disposed of. It's not in the work zone, despite what counsel keeps defining it as a work zone. It is in a dumpster. That would mean...
I'm sorry, go ahead, finish the answer.
That would mean every dumpster at a construction site needs to be locked up and would have to have additional security be placed on it.
Okay,
So, well, it would mean that you don't sort of disable the ladder, but leave it not so disabled that someone could still think they could use it.
It's disposed of, Your Honor. It's in the garbage. The plaintiff has expressed himself to be an experienced worker. If it's in the garbage, it's no longer in the work
Counsel,
zone.
there are a lot of different versions of events as to how this accident happened. It's not really for us to make those ultimate factual determinations, is it?
I think the question is whether it's a means of method or a defective condition.
That was going to be my next question. What's your position on that and why?
This is a means and methods issue. As you hit it on the head, this is a tool being used. Plaintiff made the choice to use this. There were alternate and safer material for him to use. There was
Counsel,
a
if we accept as true the allegation that this employee intentionally broke the ladder, why wouldn't that take it out of the means and method and put it into a dangerous condition case, since that's not just what tool is used and why you pick a tool?
Because it's still disposed of. It is not in the work zone. It'd be one thing if it was left there in the work zone for people to take. This is disposed of in a dumpster. Anyone at a construction site who has an experience knows this is not to be used. Plaintiff made that choice to use it, and that's what the credibility then comes into issue.
But it's supposed to be disposed of by Steve, and you say you don't know who that is.
There has not been any record as to who employs Steve.
So the allegation that it was disposed of is just an allegation, right? And the allegation that Steve bent it is just an allegation.
With that, respectfully, Your Honor, Steve's employment is at issue. Those are two different things we're talking about.
Doesn't Koch say that Steve worked for Buck?
That's his understanding, but there are other individuals that could have been named Steve on the, we don't have any record of any Steve associated with Buck.
I was just going to ask you that. You
We
represent
don't have any record
Buck,
of
so you
anybody-
don't know who Steve is.
Correct, Your Honor.
So Steve could be make-believe is what you're saying.
I'm not saying make-believe, it just his understanding of who employed him or his name could be different because it was not his employee.
Is that denial in the record?
Apologies, Your Honor.
Is your denial that Steve worked for you in the record?
We raised that point in our brief, Your Honor.
No. Is there a factual dispute in the record of your claim, of the claim that Steve works for you? The brief is not a factual.
The brief does not have the employment
I'm not talking
records.
about the brief, I'm talking about facts.
Your Honor, with regards to, I apologize, I'm not understanding.
Testimony, like testimony.
Was
I don't
there
believe that question was
affidavit, a
specifically.
deposition from your client stating that Steve doesn't work for the company?
I don't believe that specific question was asked.
So if the ladder was available and the worker used the ladder and the ladder bowed, you would agree that that was a dangerous condition?
With regards to
the ladder?
The ladder?
Yes.
It can be, Your Honor, but the issue still becomes whether this ladder should have been used or not. The plaintiff was not to use an aluminum ladder. He was admonished, as were by Mr. Koch. The baker has rungs that he could have used, and then there was a fiberglass ladder for him to use. He chose to use a ladder that he was told not to use.
Thank you very much.
Thank you, Your Honor.
Very briefly, I want to focus on the 240 part of it and what counsel said. You know, even if the court accepts Mr. Koch's testimony as being entirely true, all right, there were other causes to this accident other than something that Mr. Breslin did. There is no issue of fact. As a matter of law, the fact that an aluminum ladder was not chained down and allowed to exist in this workplace at all is a cause of this accident. The cause of this accident was the GC allowing the ladder to exist. A cause of this accident was his supervisor not making sure that he had a good ladder to be able to work with after if you want to agree with his deposition testimony, that there was nothing wrong with the aluminum ladder. He didn't ensure that Mr. Breslin had a good working device, a safety device from which to use. So on the 240 case, even if you want to credit the differentiation of facts, I think that's a differentiation of views on this. Even under Mr. Koch, the defendant's version of this, their sole proximate cause defense fails because there are other causes of this accident other than those that could be attributable to Mr. Breslin.
Thank you.
Thank you. Happy holidays.
Okay.
Happy Thanksgiving.
The next case is SR and Infant versus BMW.
Good morning. May it please the court. I'm Phil Sempervivo. I'm here on behalf of BMW North America. On April 26, 2018, Your Honor, in this court sent the case back to the lower court for a Fry hearing in relation to a remand on the summary judgment decision. For the purpose of that Fry hearing, the court was instructed to...
Counsel, let me ask you a question, because I understand you have a number of arguments, but one of your primary arguments is that nothing's different this time as to, there's still no studies that gasoline vapors by themselves cause birth defects accepted in the scientific community as opposed to the constituents. Is there absolutely no study in the record different from, because I know there are new studies in the record that support plaintiff's position that the vapors themselves can cause birth defects?
You're absolutely right, Your Honor. The law hasn't changed and science hasn't changed on that topic. We've gone through the articles, we've discussed them in the brief, and I sense that Your Honor would rather I not go through them now.
This case was to the Court of Appeals, was it not, and dismissed?
Correct, Your Honor. It wasn't dismissed, but all the experts were stricken at that time. We moved for summary judgment without the experts there. In response to the summary judgment, plaintiff then recast one of their other experts and then brought in new experts, and this court allowed us to fry them, essentially.
What did the trial court not pick up then? Because obviously the trial court here came out with a different result and allowed this case to go forward. So what did the trial court miss in allowing the case to go forward?
Well, Your Honor, unfortunately, this was a several-year project with the Fry hearing, with two separate judges at the trial court. The one that ultimately made the decision came at the tail end after COVID and a retirement of Judge Freed. The trial court, in rendering the decision ultimately, erred in our opinion on all accounts. Mr. Zucker, his methodology was the farthest I've ever seen from science in relation to even the Nemeth case recently, where the Court of Appeals found that there was no scientific expression. One of the things pointed out by Justice Friedman, that there wasn't even a test of an available bathroom at the situation. Here, Mr. Zucker didn't test a single thing. He didn't measure a single thing. He put together a methodology that was layered one step on top of the other, and they all failed. And when they fail, even if one of them failed, but all five failed.
What was wrong with methodology?
Well, it's all speculative and it's all assumptions. For instance, he assumes that there was a crack in this fuel hose, and the only information he has on that is a repair order in the dealership in 1991. No details other than it says split fuel hose to fuel rail. Well, Mr. Zucker makes assumptions and speculations on just even identifying the alleged crack. He says that the service technician must have had 20/20 vision, must have removed it from the vehicle, peered down it, to determine that there was actually a crack. He has no information of where the crack was, but he makes an assumption that it was over the engine compartment, although the hose is long and it goes to the entire engine. He then goes on to discuss the leakage from the hose of this fuel, where he has no information on the length of the crack because he wasn't able to even speculate on that. He does no testing on leakage from a fuel hose that he's never even obtained an exemplar of. He didn't even take apart any parts of an exemplar car whatsoever. He went to an inspection, no measurements. He took a few photographs. And actually, some of those photographs don't contain the areas where he says that there was a breach in a firewall. And, I mean, the breach in the firewall was one of the most outlandish discussions that I've ever heard from an expert on the stand. He points to one area where he believes there might have been a gap, and he estimates the steering wheel shaft was 2-inch diameter. On cross-examination, I corrected him to that it was essentially 16 millimeters.
So that was on cross-examination at the time of the DeBene essay deposition, correct?
Oh, actually, no, at the Fry hearing. He changed
Oh, at
twice.
the Fry hearing, okay.
Your Honor, every time that we put a hole in Mr. Zucker, they recalculated.
I wanted to ask you a question, though, about the use of the DeBene essay deposition. Since that's in the nature of trial testimony, I don't understand the theory under which you argue that that should be a basis to renew essentially a pretrial decision which had already been made and completed, that is the Fry decision. I mean, you certainly in the middle of trial, you wouldn't say, oh, so-and-so testified to that, so now let's go revisit the Fry decision, right? So isn't that the same as what you're doing here?
It's a good question, Your Honor. So when we had the DeBene deposition, we had a ruling from the lower court on allowing the methodology that Mr. Zucker had put out during the Fry hearing. He changed it for the third time on several points, and to the sense that he was not following any of the methodology that he had put before the court during the Fry hearing. And our view was if he was going to testify on something completely different, we had to revisit and re-argue the Fry issue.
Is there any precedent for using a deposition in the nature of trial testimony for revisiting a pretrial decision?
We do cite one case, Your Honor, that allowed it in the federal court. I don't have a state case on that, though I think the facts of this case are quite unique in the sense it was an ordered DeBene deposition following the Fry hearing. There was a gap of time, and we just had rulings specific to what his testimony and methodology would be. It completely ran contrary to it.
Thank you very much.
Thank you.
Good morning, may it please the court. My name is Danielle George. I'm from the law firm of Phillips and Palicelli on behalf of the plaintiff,
Let me
Sean
start with the
Reeves, known
same
as
first
SR.
question. I know there's going to be questions about Zucker, but
No problem.
what is different in terms of, has changed since this court's specific finding that it's not enough to show dangers with the constituent parts of gasoline, that there has to be some studies that actually, accepted in the scientific community, that gasoline vapors themselves cause birth defects? What studies have there been since the prior decision which specifically find and are accepted in the scientific community that gasoline vapors cause birth defects?
Your Honor, I'm glad you asked that question at the outset. There is a host of studies that show gasoline constituents, including the BTEX chemicals.
But no, but we've already held that constituents is not enough. I mean, that was a specific holding of our court. So in order for you to change the result, you would have to have some study that has since been produced that's accepted in the scientific community that gasoline vapors cause birth defects, as opposed to that the constituent parts of gasoline vapors cause birth defects.
Understood, Your Honor. Well, there are a host of studies, as I mentioned, including the Zhu study, which is XU, which concerns pregnant women working in a petrochemical plant in China, and there was an increased risk of birth defects in the women who were exposed to the gasoline vapors there. There are also studies of low-level exposures to gasoline vapors and their constituent chemicals in terms of the study called SLAMA and the study called LUPO, which were described at length in our papers and also in Dr. Barer and Dr. Hatak's affidavits in their lengthy Fry hearings, and also in Dr. Barer's trial testimony, which was taken already. So you can't look respectfully at gasoline as a single entity. It is not. It is a mixture. It is a mixture of...
So, counsel, I have limited scientific knowledge, okay? I think a lot of us can say that together, right? But I do know that a chemical unto itself is separate from another chemical unto itself. And what we're talking about here is what happens with the combination of different chemicals. And that's where this problem with the components goes. So if you talk about the toxicity of a given chemical, what that toxicity is when there's constituent chemicals that come together as one is really the crux of the question. And we know that the causation can't be established by using a synthesis of studies concerning the constituent chemicals. So where do you stand? I mean, after Nemeth, all of these cases are in a very, very hard place, aren't they?
Nemeth is completely different from the case at Barr for several reasons. First of all, gasoline, although it's considered a chemical, it is a mixture of many chemicals. And so it's as if you use the analogy of someone who's drinking alcohol. We know alcohol causes birth defects.
Counsel, that's a given.
Very important.
Well, if you go to the gas pump, it shows that it's got different things in it. So
yes,
try to answer my question.
What we did here and what was not done in Parker or Nemeth or Olson or any of the other cases is that we quantified the level of constituent chemicals and the level of gasoline. We quantified that in terms of parts per million, not just of gasoline vapors, but parts per million of benzene, parts per million of toluene. It was quantified and scientifically expressed in a manner that complies with Parker.
Counsel, I think that the question of quantification is different from what my colleague is asking about. It seems to me she's posing a question about proof that gasoline has an effect, regardless in it as a whole, whether or not there's proof of the effect of its constituent parts. But it seems to me the question of quantification gets to the issue of the validity of Mr. Zucker's testimony, which in some ways seems to me even more problematic. And I'd actually like you to address the particular example of that counsel described, of his relying on the note by an unnamed mechanic on which he based his testimony, apparently, about the size of the crack through which the engine fuel vapors allegedly escaped, which doesn't seem to me to be, I couldn't perceive any part of the scientific method on which that was permissible.
Okay,
so
so
could you address
there's
both of those things?
Yes, I can address both of those things. So in terms of general causation of whether gasoline can cause birth defects, if you look at the McMartin case, it shows that gasoline and solvents during the first trimester, exposure to those chemicals, including gasoline, will cause malformations. The Hatak study shows a 13-fold increased risk of birth defects in pregnant women exposed to aromatic hydrocarbons, just like gasoline. And the Grandjean article shows a review of 110 scientific articles showing that chemicals known to be neurotoxic, including the gasoline constituents of benzene, xylene, toluene, et cetera. And so there's ample scientific basis for the teratogenicity of both gasoline and its constituent levels.
Respond to the other part of her question?
Yes. With respect to Mr. Zucker, there is a vast factual record
Well, let's
upon which
start
he
with the
relied,
fact that he
including
relied-
BMW's own
Excuse me,
description
let's
of
start with the fact that he relied on the note from an unknown mechanic about the size of the
Yes.
of the
So he didn't-
gap, and then he extrapolated from that by deciding the mechanic must have been looking at from 16 inches away and so on.
He did not extrapolate the size at that point. He used scientific concepts under optical engineering, and optical engineering is what people can see.
Those optical engineering methodology to the alleged facts of the mechanic's observation.
He did, and it's in his affidavit, and in fact, he includes on page 15 of his affidavit, which is record 946, an actual diagram of why that is valid.
You agree that he relied on this note from the mechanic, right?
He relied on the fact that the mechanic saw a split in the fuel line, and in order to see a split in the fuel line, the split had to be at least a certain size in order to be discriminable under the laws of optical engineering, of which Mr. Zucker has patents in his name, and he is very well qualified to
Any further
testify.
questions from the bench? Thank you very much.
Thank you very much.
Unless your honors have further questions, I can waive the huddle.
Any further questions? Okay, thank you very much.
All right, thank you.
The next case is Isufi versus Prometal.
May I proceed?
Yes.
Good morning, or if it is still morning. I thank you for entertaining this the last day before Thanksgiving, the last argument. My name is Brian Lustbader. I'm a member of the firm of Venable LLP, attorneys for the defendant, Prometal Construction. And I bet you've heard this a million times. If any case is deserving of reversal, this is the case to do it. But I don't know that you've heard it as many times on this particular issue where a trial court, the Supreme Court justice, has abdicated her responsibility time and time and time again throughout the
Counsel, it sounds like there was a very robust discussion at the final approval settlement conference where the judge did give counsel ample opportunity to make arguments and question counsel's ability to have standing to raise some of the concerns that counsel was asking at that point.
Thank you, Your Honor. That's I was just reading that very transcript as I was waiting for this particular argument, and the fact is she stifled counsel for defendant every which way. She kept screaming, legal, 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 law, 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 tell me how this works, and didn't
Well, she
listen
was
to a
asking
word
you
she
for
said.
legal authority. That's what judges do.
There's no question that she's entitled to legal authority, but she also has to listen to the arguments. The arguments are plain. It's very, very simple. In this particular case, the procedure was done in the inverse way that all of the other labor law cases are done. Typically what happens is the parties meet, they go, I just did this in two other matters. The parties meet, they work out, that is, I represented the contractor and with a different defense plaintiff's counsel, you work out terms and conditions, who qualifies, who doesn't qualify, what are the proper amounts to be paid to each of them.
Counsel, didn't you agree to the settlement, though? I understand that you're saying that this is not the typical way you come up with a settlement figure, but we did have a little twist here because a lawsuit was being brought against Prometal in federal court on the surety bond.
Exactly.
So maybe that's what caused things to be done in a different fashion. But there's no dispute here that your client did agree to the settlement and did not appeal anything about that settlement. So how can you then, at the final approval, go back to something you already agreed to?
Your Honor, CPLR 908 requires the judge to conduct a full and fair settlement hearing after the parties have agreed to something. The fact is, in this case, she supposedly put in two different methods of safeguards. One, you're going to have a mediation where the mediator will broker a settlement, not make a decision. And two, I will have a settlement hearing thereafter. She did neither. She allowed the mediator to make a decision, and then when you came to the argument that Your Honor just referred to, she said, well, the mediator ruled. The mediator had no right to rule based on her own direction, and she ignored it. This is what I'm talking about abdication of responsibility. I'd like to address the attorney's fees if I can, unless Your Honors have other
Although
questions.
you didn't raise it below, so I don't know how you could raise it now.
What?
You didn't raise an objection below, so I don't know how you have the ability to raise an objection at the appellate level.
Well, we did raise the objection. I'm not sure
The amount of the attorney's fees?
Yes, in the settlement hearing, Your Honor, yes, absolutely. So we have and in any event, the court has the authority to rule de novo. This court can and should reverse the award of attorney's fees to the plaintiff's attorneys because they are outrageous, higher than any other case. We have researched this extensively, higher than any other
Are
case.
the counsel fees more than the amount of the settlement?
I'm sorry?
Are the counsel fees more than the amount of the settlement?
Yes, they're more than the amount paid to the individual workers, Your Honors.
Aren't they
The total?
Aren't they at 30.9%?
No, that's a misleading figure. The settlement agreement specifically mandated that the most the defendant could pay would be $2.1 million. In order to distract the court from that figure, the plaintiff's attorneys cite a $3.2 million
I don't understand.
figure.
I thought you were just repudiating the settlement agreement. Did you change your mind?
Well, they're trying to affirm it, so they're saying we're complying with the settlement agreement. This is their argument. I'm telling you that their argument misleads the court in saying by its 30%.
Where does the 3 million and the 2 million come from?
I'm sorry?
Where does this discrepancy between the 3 million and the 2 million come from?
It's the 2.1, the settlement, 3.1B of the settlement agreement specifically limits the payment to the class to between 1.7 and 2.1 million dollars. That's the total range that it could be in. The parties had never agreed on it, but that's the maximum they could get. And their figure, even if you use the 2.1 figure, that's 47% of the total amount.
So where did the 3 million figure come from?
That was another figure quoted in a different portion of the agreement, and it was definitely not binding on the parties. The only thing that could have been binding was the 1.7 to the $2.1 million, and that it's also way in excess of that in terms of the percentage.
Thank you, counsel. You have time
Thank
for
you, Your
rebuttal.
Honors.
Good afternoon, Your Honors. May it please the Court, my name is LaDonna Lusher. I'm from Virginia and Binder, and I represent the plaintiff's respondents. The trial court did not...
Where does 3 million versus 2 million discrepancy come from?
So the settlement it's a class action settlement, and there is a gross fund that is provided to all of the claimants for the settlement, and that was $3.2 million, and that is in the settlement agreement, in the same provision that my adversary is referring to. So there's a $3.1 million gross settlement fund. Out of that gross settlement fund, the claimants get paid, the class members, the attorney's fees, the class administration fees, they all come out of the gross fund. There is a plethora of case law that we cite in our brief that talks about how in class actions...
Aren't there other provisions which limited it, like the 2 million figure?
There are other provisions that are... There are other provisions that talk about things that happen if the claims and all of the fees come in at a certain rate. For example, the 2.1 figure refers to if the claims and the settlement administration fees and the class counsel's fees all totaled to be within 1.7 million and 2.1, that would trigger another provision, which is 3.1B of the settlement agreement, where the parties would agree to go to they would agree to try to work things out amongst themselves about allocations, or if they couldn't agree to work it out, they would go to a mediator who would then hear and decide. If the claims came in above 2.1, which is absolutely possible along with the class counsel's fees and costs, say everything came in at 2.5, it still wouldn't be above the 3.1 settlement figure. However, at that point, there was another clause, which is 3.1C, where Pro Metal could have elected to terminate the settlement at that point. These are a couple of creative clauses that mediators have encouraged and that my firm, who does a lot of class action settlements, have seen in other agreements because defendants often want some type of safety provision to have choices. If they think that the claims and the administration fees and the class counsel's fees are going to come in higher than what they anticipated initially. So the fund, the class counsel's fees are based off of a percentage of the total common fund. And there's case law that we cite in our brief that said that that is routinely proper, that it's been granted in a plethora of other cases, and generally what's awarded is about a third of the settlement
Counsel,
fund.
when I mentioned the figure of 30.9%, your adversary said, no, the class counsel fees amount to 41%.
So they're actually doing the percentage off of the claims that were given to the class members, the amount of money given to the class members, and that's an incorrect calculation. We also cite a plethora of case law in our brief that says that you do not base the percentage of attorney's fees off of the claims amount that was claimed. It is actually based off the gross amount of the fund. It goes back to the whole purpose of the Fair Labor Standards Act and New York labor law when you're looking at wage and hour cases. A lot of times class members have very low wage claims. Allowing class counsel to ask and make a request for a percentage of the fund is an incentive for class counsel to take on these types of cases and to advocate for these workers and litigate their claims. Otherwise, a lot of times they would be without any redress at all. This has been addressed by this court. It's been addressed by many courts that percentage of the fund is common, and generally it's 1/3. And even if this court were to have any doubts about the fees, you can also look to the lodestar multiplier, which the trial court also did. Our lodestar multiplier analysis, which is often used as a cross-check to the percentage of the fund fee amount, is only a 1.29 multiplier in this case. And that was at the time that we made the motion to, for re-argument, that it's the order that they appealed. There have been many more hours that have been put in since then, but the lodestar analysis is also what has been routinely awarded in these cases.
Thank you. Are there any more questions from the bench? Thank you very much.
Thank you.
May it please the court, Mark Gamel from Tory Lentz, Gamel, Gary, and Rittmaster for Respondent RLI Insurance Company. I'm going to be very quick and limited, I promise. Appellant's counsel referred to an inverse procedure to use mediation. And I want to just remind the court that that was one of the critical terms of the original settlement placed on the record in federal court before United States Magistrate Judge Freeman when the federal action to compel the delivery of $3.9 million of collateral to RLI for its risks in this case was settled. And that can be found at record 489, lines 12 to 16. And that's because the best we could do in the federal court was to say instead of giving RLI $3.9 million of collateral now, they would rather go settle the state court action, and we needed terms and parameters. And one of those parameters was that it will be at least $1.7 million, up to $2.1 million. At 2.1, they had an option to exit. It didn't disappear. It wasn't rendered void. At 2.1, they could opt to exit. But if it was over 1.7, then there would be what was called binding mediation. And we all agreed to that, and it's in the federal court record. And it was the way we inserted a vehicle, a mechanism for how the number would be arrived at if it was between those two. It wasn't inverse, it wasn't backwards, it was the way it was done and agreed to by all. The only other thing I want to talk about is this oft-repeated accusation that this settlement was the result of coercion or duress by my client, RLI. It is clear in the law that you can't ground a claim of coercion or duress on another party simply trying to exercise their legal rights. And RLI had a judgment of specific performance. We were going about enforcing it, and you can't say that you were coerced because RLI was going to enforce their judgment. And you can't claim coercion or duress if you wait 2 years to raise it.
Thank you very much, counsel.
Thank you, judges. Appreciate it.
I'll be very brief, Your Honors. Excuse me. I'll be very brief, Your Honors. Just read the decision. Where is the finding of fact, the conclusion of law? If you look at her decision, and I have it right in front of me, there are 10 points listed here. Point number 8 is defendant RLI, who just spoke to you. does not oppose this motion. There's not even a reference to pro-metal in here. It doesn't say she opposed it or is in favor of it. So the second point I want to make is when she asked for counsel for Virginia and Ambinder, the claims counsel.
Who is she?
I'm sorry, Judge James, I apologize, Your Honor. When Judge James requested the materials, she rendered a decision. Where is the findings of fact? Where are the conclusions of law? She said they just submitted their bills. You'll look at the bills, and if even a cursory review would tell you there's overbilling, there's billing for charges they had no right to charge for. A million things wrong with them.
Thank you very much, counsel.
Thank you very much, Your Honors. Have a very happy Thanksgiving.
Happy Thanksgiving.